Andrew, you divided between retributive and reparative justice, and sort of used one to describe the rule of law and the other to describe transitional justice. I wanted to ask all three of you whether you consider that those two types of justice to always be consistent, or in fact whether there could often be tensions between those two forms of justice. Betsy, you talked about the sort of way in which transitional justice is perhaps more connected to the international justice community. And I'm wondering, I think probably rule of law practitioners often see themselves as international development practitioners and not international justice practitioners. And I wonder if that affects the way that either goes about their practice, and if there's any comments on that. And then in both Betsy and Olivier's comments, there were really on this issue of sequencing and time. And it's probably our analysis that just doesn't happen, that we don't think enough about the order of things, and particularly the order of things in terms of transitional justice and the rule of law. And I wonder why that is. Why are we not capable of sequencing? Volunteers, but perhaps start with Olivier this time in reverse.
Yeah. Okay, thanks, Jim. Well, the American Bar Association is actually implementing right now in Mali a State Department funded project on transitional justice to try to establish the foundations of transitional justice. And we are doing it jointly with Freedom House, that I noticed in the room. And I think the issue of actually sequencing, or the issue that lead to the interventions that are labeled as transitional justice and those labeled as rule of law are not part of a sequenced framework, but I'd rather say more part of a thoughtful framework of post-conflict intervention. Is you've got plenty of reason to put in question or to put at play to explain that. One is sometimes it's not necessarily the interest of certain donors or donors in general to push for transitional justice mechanism per se. Sometimes donors think it's a little bit sensitive to push, for an example, let's say for prosecutions, especially in a conflict where presumably some of the interlocutors for peace could have been those who committed violations, gross violation of human rights. Therefore, it becomes very difficult to put like prosecution as a priority in this country, because if you do that, actually you're going to really infringe, you're going to impact negatively on a peace process. And yet, in a post-conflict situation, in terms of hierarchy of priorities, you may not necessarily want to have prosecution first and peace later. You may want to have actually conditions of peace that are going to allow prosecutions to take place efficiently. And then for you to do that, you need rule of law interventions. And I would rather try to highlight the fact that we need maybe on a practical perspective to look at transitional justice and the rule of law as practical driven initiatives rather than theoretical or conceptual. And on that note, I will consider transitional justice as a strategy to address mass atrocity, and I will consider the rule of law as an enabler, something that actually enables you to kind of deal or to put your strategy in place properly. So with that in mind, I think it's about when do you think the strategy will be efficient? What do you actually have to put in place to have it done properly? What are the enablers that you need? And the rule of law can do that. But most of the time, in a very early post-conflict moments, none of those are actually the priority, transitional justice or the rule of law. So therefore, it's not possible to reflect about them strategically. It's not possible to reflect about them in the long term. It's over time, and as time is evolving, that people are thinking, oh, hang on a second, we forgot that we're dealing with people who could have committed atrocities. We're putting them in United Nations planes. We are making them our interlocutors, and then these are people, well, we have allegations of serious atrocities. Maybe we should think of some kind of a mechanism of accountability to try, not necessarily criminal accountability, maybe some sort of vetting processes to make sure that we make principles with who we do business and who we do not do business with. So for me, I think if we have in mind that TJ is a strategy, the rule of law is an element to help that strategy, and in the end, the rule of law is nothing else than a set of governance principles. And then maybe putting them on the same level of comparison may be a little bit unfair for the two concepts.
Thank you. Betsy, on any of the three questions?
Yeah, I'll maybe take them in reverse order, or at least address a couple of them in reverse order. I think your point is fair about, I made the distinction between international law and domestic law as being the frameworks for transitional justice on the one hand and rule of law on the other. I think there's also a dichotomy in these communities of professionals between development professionals and international law or human rights professionals. And I think related, there's also, there's some funny cultural differences and that between these communities. And I was struck in the last panel, because I usually go to international law conferences these days. I haven't been in development conferences recently, and I had to think for a minute what all the acronyms meant and reorient myself even to the language of development. And I got it after a few minutes. But there's some of that. We don't know each other's lingo. We don't know each other's frameworks. There's also a very important difference in approach and the kinds of partners that those in the human rights, international justice, transitional justice world engage versus the rule of law and development community. I'm painting with pretty broad brushes here, but there, historically, rule of law assistance was about partnering with governments, and importantly, continues to be that way. There's a lot of civil society engagement, but historically, transitional justice, human rights, international justice types, government is anathema. That's the enemy, right? They're the human rights abusers or those who need to be held accountable. And I think there's a lot of distrust about any partnership with government. And I think that is a problem. Those kind of different approaches and different kinds of partnerings that take place in this space are problematic to realizing the synergies that might otherwise exist between transitional justice and rule of law, between development assistance and international human rights advocacy or justice efforts. In terms of sequencing, why don't we get that right? We're often in these circumstances in crisis mode, right? There's not a lot of time to step back and think about what's the right order to get us where we want to be 5 years from now or 10 years from now. It's troubleshooting in an immediate circumstance. I think actually that's a challenge to all of us to think about whether we can't try to take advantage of the quiet moments in between crises to build a foundation of rule of law and transitional justice that can then be tapped when the crisis erupts. And I think the Rome Statute, the International Criminal Court, creates a framework for that with its complementarity regime and requiring states parties to the Rome Statute to implement the capacity to undertake transitional justice or international justice accountability in cases of mass atrocities. And yet, about half of states parties to the Rome Statute have actually implemented that statute. That's a perfect rule of law development assistance problem that could be worked on fruitfully in non-situation countries, non-conflict countries, to lay that groundwork that could then be tapped when we need it. And so that's a much longer term kind of sequencing, but I think could be fruitful. One last point I want to just put out there, and we can pick it up later, is I do think there is an important difference in geography, whether the transitional justice or accountability effort is a localized effort versus an international effort, in the extent to which it will contribute to rule of law development. And I think, again, painting with broad brushes, but typically the more remote the transitional justice forum is, the more difficult it is to have the synergies with rule of law on the ground. And so we should be, if we care about this and taking advantage of these synergies between transitional justice and rule of law, we should be looking for models where the transitional justice can be locally situated. With the international courts on one end of that spectrum and domestic prosecutions or truth commissions at the other, and that latter end of the spectrum being more synergistic with rule of law.
Okay, lots to dig into there, so I'll sort of just improvise and riff off of what I heard. First of all, I think you were interested in tensions between retributive and restorative justice. Yep. Okay, so let me answer it this way. Getting it right is the challenge that we have. And so on the one hand, when we talk about retributive justice or punitive justice, and we're talking about the investigations and the prosecutions, that again is the perpetrator centered. And is that enough for the victims? Does that repair the harm, create the social cohesion that's needed to move forward, as well as just removing the bad actors and giving us a sense of almost even, I don't want to say the R word, but revenge. So how do we balance that out with the compulsion that many of the victims, and we hear this in many of the conflicts, they want acknowledgement of what happened to them. Now, is persecuting a bad guy give them that acknowledgement? It could, but I think we also have to think that's not enough, and we need to think about ways of through truth seeking, really provide that opportunity for individuals to have that moment to tell their story. But at the same time, not let the bad guys off the hook. So I think there's a little tension. And the same thing with reparations. So if you're going to remedy harm for suffering, and then there's different types of reparations, as we know. There's financial, material, symbolic. Is it enough just to give somebody their house back or to provide them with some financial compensation after they've really suffered a life-changing experience, and to buy them off? I mean, that's something that we always have to worry about. So I think there's tension there. So we have to figure out how all the retributive and the restorative work together, so that we're covering justice on all the bases of justice. Just tensions between rule of law and transitional justice when they inhabit the same space, and I'm glad that you referenced that, because we see them inhabiting the same space even in Ukraine or every place. It's just coming up all the time. So, and they are both inherently political. This has been referred to in many ways, because rule of law requires that buy-in of our partner countries at very high levels to, I think, be effective. Well, at the same time, transitional justice is aimed, in many instances, right at those high people. So look at the situation in Kenya, for instance, where the transitional justice measures really go, including at the international level, they go right to the top. So I think there's a tension there for both rule of law and TJ. On the sequencing issue, again, this is key, as well as calibrating the different measures together. So at what point do we put TJ on the table, and how? Do we bring it into peace agreements, like what's going on right now in South Sudan? Do we negotiate it in there so that it's on the table, or does that sort of complicate the transition? If we do go with it, what do we go with? Do we go with the prosecutions, or do we go with the other forms of truth and reparative justice? And then on the time horizon, I agree that these are part of the same intervention, and we have that maximum, or that moment of maximum influence sort of at the end of a conflict. But we're also seeing, and so much of this is context specific, it could take years for the political will and the other I guess, criteria to be there for an effective intervention. I mean, right now we're looking at 25 years I think, and that's how long it's taken Brazil, for instance, to put in place a Truth and Reconciliation Commission. And again, we see prosecutions happening very late.